How many stops does it take before the law admits it is broken? 1, 2, 8, then 9? For Edward C. Lawson, a black businessman and civil rights activist in San Diego in the mid-1970s, the answer wasn't 8 or 9, but something far more relentless. Approximately 15 stops and detentions in less than 2 years under a vague stop-and-identify statute that gave police extraordinary discretion to demand credible and reliable identification and a satisfying account of why he was where he was. He was walking, sometimes hitchhiking, because he preferred to move through his city on foot. That everyday choice became a kind of offense in the eyes of a law written so loosely that it transformed an officer's suspicion into a legal trapdoor beneath an innocent person's feet. Lawson refused to accept that simply existing in public space while black could be treated as a crime in slow motion. He took his case to court, and in 1983, to the United States Supreme Court. There, the justices said out loud what Lawson had been living: a law that gives police virtually complete discretion to decide what makes an identity credible and a presence accounted for, violates due process, and invites arbitrary enforcement. The statute fell. The rule of law moved a step closer to what it promises on paper. This is not a story about a single bad stop. It is a story about a system that multiplied one man's humiliation into a pattern, and the grit it took to turn that pattern into a constitutional reckoning. It is also a blueprint for the rest of us. Lawson's path from curbside detentions to the nation's highest court shows how everyday courage, sharpened by persistence, can redraw the line between reasonable inquiry and unlawful control. The victory didn't just vindicate one person, it tightened the rules for everyone who would ever be asked again to prove they belonged on their own sidewalk. To understand Edward Lawson's journey, begin with a simple preference. He liked to walk. He walked short distances and hitchhiked longer ones, insisting on moving through his city in ways that felt more human scale than the private bubble of a car. He also held an idea that should never be controversial in a free society. A person in public space should not be required to carry a script explaining where he's going and why. In the mid-1970s, this principle kept colliding with a California statute, Penal Code Paragraph 647E, still bearing the DNA of older vagrancy laws. The statute authorized police to stop any person who loiters or wanders without apparent reason and demand credible and reliable identification and an account of their presence to the officer's satisfaction. Vagueness was not an accident. It was the mechanism. It made compliance less a matter of law and more a matter of appeasing an officer's subjective comfort. Between March 1975 and January 1977, Lawson was detained or arrested roughly 15 times under this provision. Officers testified to stopping him for walking, an ordinary act rendered suspicious by context and bias. Sometimes he was prosecuted. Sometimes he wasn't. Always, the same pattern haunted the encounter. What counted as credible and reliable ID? Who decided whether an explanation was good enough? Because the statute failed to define these standards, the real rule became, whatever convinces the officer in front of you, a formula that predictably fell hardest on those already seen as out of place in that era, especially black men walking in majority white neighborhoods. If the text of the statute took liberties with language, the constitutional doctrine that polices such liberties has been steady for decades. A criminal law is unconstitutionally vague if it fails to give ordinary people fair notice of what conduct is prohibited, and if it encourages arbitrary and discriminatory enforcement. That void for vagueness doctrine is not a technicality. It is due process made practical. It is the rule that says the government cannot criminalize a person's day by handing frontline officers a blank check to decide what is suspicious on the fly. Lawson's case would test whether a more modern stop-and-identify law could survive this principle, or whether it amounted to a new name for an old method of control. The public record doesn't tell every biographical detail about Lawson's early life, but it shows enough to understand his resolve. He resisted on the spot by insisting that walking is not a crime. He persevered in court by arguing that laws must say what they mean and mean what they say. He turned the drip of indignities into a civil challenge that would climb from a federal district court to the Ninth Circuit, and then to the Supreme Court. Along the way, he distilled a sprawling issue, how race and discretion collide on the street, into a focused question of constitutional law. Can a state compel a person to produce credible and reliable identification and an account of their presence when the statute provides no clear standard to guide officers and citizens alike? The answer he pressed would become the answer the court gave. No. To see why Lawson's case mattered, you have to feel the curb under your shoes. You are walking. A patrol car slows. The officer asks for ID and wants to know why you are here. Because I live here, you say. Or yeah, because I'm going to a friend's place. Or you decline to engage because you believe you shouldn't have to justify your existence. The officer's reply is not a law, it is a posture. That's not good enough. And now you are in a legal net with no mesh size you can read in advance. The statute says your ID must be credible and reliable, but offers no definition. It says you must account for your presence, but to whose satisfaction? The stop stretches. The street watches. Your day bends toward an outcome that depends less on what you did than on how you are perceived. Lawson lived this scene not once or twice, but roughly 15 times in less than 2 years. Court records describe officers stopping him while walking, sometimes at night, sometimes in neighborhoods where his presence was seen as anomalous. They asked for identification, when he produced something, or when he asserted his right not to. Some officers decided it wasn't reliable, that his explanation was inadequate, that he needed to be detained longer or taken in. Periodically, he was prosecuted under the statute. The burden of proof shifted in practice, from the state showing why a stop was justified to the citizen proving, again and again, that simply being there was credible. Beyond the paper trail lies the human cost. Every stop corrodes trust. Every detention broadcasts a message to neighbors and passers-by. Here is someone you should fear or avoid. Friends begin to worry that your presence will draw patrol cars to their doors. Employers tire of your late arrivals because a walk to the bus turned into a legal timeout. The harm is cumulative, and it does not end with the "no charges filed" box checked. In Lawson's case, the harm became a civic teacher. He learned how a single vague phrase, credible and reliable, could be stretched to cover every whim. And he learned that the one remedy capable of changing the rule for everyone was not a smoother explanation at the next stop, but a court order redefining the law itself. He filed a civil action arguing that Paragraph 7E was facially unconstitutional, invalid, in all its applications because it failed to provide clear standards and invited arbitrary enforcement. The Ninth Circuit agreed, striking the statute as impermissibly vague. California appealed, and the Supreme Court took the case to decide a narrow but decisive question. Not whether the police may ever ask someone to identify themselves during a lawful stop, but whether the state may criminalize the failure to produce police-approved, credible and reliable identification and a satisfactory account of one's presence when the statute gives no concrete guidance about what either phrase means. At the Supreme Court, the legal issue was straightforward, even if its implications were profound. Justice Sandra Day O'Connor, writing for the court, described FAR 647E as providing no standard for determining what a suspect has to do to satisfy the requirement to provide a credible and reliable identification. In practice, she observed, the law gave police virtually complete discretion to decide whether a person had complied, exactly the kind of boundless authority the vagueness doctrine is meant to prevent. The opinion linked this discretion to a deeper danger. Such undefined standards furnish a convenient tool for harsh and discriminatory enforcement, especially against particular groups deemed to merit their displeasure. The court affirmed the Ninth Circuit and held the statute unconstitutional. Wrapped inside those judicial sentences is the lived physics of street encounters. When a statute lacks standards, the human mind supplies them, filling gaps with habit and bias. Those biases can be individual. More often they are systemic, encoded in training and culture. A law like Paragraph 647E did not invent those biases. It amplified them, giving them a legal frame to hang from. Lawson's victory didn't say police could never ask for a name. It said the law cannot punish a person for failing to satisfy a standard the state refuses to define. In other words, the government cannot convict you for violating a rule that exists only in an officer's head. The struggle here does not look like the classic montage of bullhorns and rallies, though public witness matters. It looks like a person walking again the next day, knowing he might be stopped. It looks like sitting in a lawyer's office, turning vivid humiliations into dry affidavits that the court will respect. It looks like resisting the urge to move along permanently, choosing instead to stake a claim on public space that the statute tried to make conditional. The resistance is legal as much as it is moral, translating lived experience into doctrines judges can apply, into phrases like void for vagueness, that don't capture the ache but can fix the rule. Lawson's case also lives in a broader tradition of challenges to status crimes and vagrancy laws, statutes used for generations to mark certain bodies as always already suspicious. After the civil rights era prompted the demise of the most blatant versions, states often rewrote them with modern language, swapping vagrancy for loitering and adding what sounded like neutral checks. But neutrality without standards is an illusion. The old dynamic reappeared. Police empowered to demand that the wrong person in the wrong place explain themselves to the right person's satisfaction. Lawson's suit took aim squarely at that dynamic, insisting that the law must speak clearly, or not at all. Community, too, plays a quiet role in resistance. Imagine being Lawson's friend, his neighbor, his co-worker. You see the pattern. You witness the stops. Maybe you testify. Maybe you help gather documents. Maybe you simply keep walking with him. Two people where there used to be one. A subtle rewriting of the stage on which discretionary power performs. Part of the reason Lawson's case resonated is that so many people recognized the pattern in their own lives. His courage made the familiar visible to those with power to change it. Legal resistance requires discipline that feels almost inhumanly patient. Lawson filed, argued, waited, appealed, and waited again. He navigated courtrooms built of marble, where the harms he suffered could sound too ordinary to be urgent. He kept the focus sharp. Not every police request is unlawful, but a statute that punishes the failure to comply with undefined demands is. That focus pulled the justice's attention away from culture war abstractions and back to a basic constitutional principle. A criminal law must be clear enough for people to follow it and narrow enough to prevent arbitrary enforcement. His resistance also had a pedagogical edge. Once the Supreme Court spoke, the decision didn't stop at California's border. It reverberated in conversations about how states draft stop and identify statutes, about what officers may require during a lawful investigatory stop. It's about how courts should review laws that sound technical but hide discretion. Some states amended their statutes to specify what identification means, often a name, sometimes a birth date, standards later litigated in other contexts. Others narrowed the conditions under which such requests could be criminally enforced. Lawson's struggle taught legislators and police chiefs that guarding against vagueness is not optional. It is the price of writing laws that a free people can live under. The turning point is a Supreme Court opinion that reads like a translator between lived harm and legal remedy. Justice O'Connor's language is matter of fact, but the stakes pulse beneath it. Section 647E contains no standard for determining what a suspect has to do to satisfy the requirement to provide a credible and reliable identification. No standard there means no standard on the street, which in turn means standards get invented on the fly by officers, influenced by training and bias, and enforced against those most likely to be seen as out of place. The court called this out as a due process problem, because a vague law encourages arbitrary and discriminatory enforcement. That sentence is the hinge on which Lawson's world turned. It pulled the experience of being stopped for walking while black into the light of a doctrine designed precisely to prevent such governance by hunch. A Supreme Court case can seem like a distant procession, briefs, arguments, opinions. But for Lawson and people like him, The decision changed what could happen at the next corner. After Calendar, states that wanted to retain stop and identify provisions had to define them with specificity. What exactly must a person provide during a lawful stop? Under what conditions can refusal be punished? What standards guide officers' discretion? The solution to vagueness is not more power, but more clarity. The climax of Lawson's story is that clarity restored. The government's rules must be knowable in advance and applied evenly, or they cannot be used to convict. The symbolic charge of the moment matters, too. A black man who was stopped roughly 15 times for walking or hitchhiking pressed his case so far that the law itself changed. The number of stops is not trivia. It is the measure of the burden one person carried to do what the Constitution is supposed to do for all of us, without asking. It is also a rebuke to any narrative that treats constitutional progress as inevitable. Nothing about this outcome was inevitable. It was fought for, step by step, courtroom by courtroom, with an insistence that the burden of justification belongs on the state, not on the citizen trying to get from one place to another. And yet, even at its most triumphant, the climax resists sentimentality. The court did not say that police could not stop people. It did not abolish investigatory stops. It did not declare that identifying oneself is always optional. It said a narrower thing, that a law as loose as Paragraph 647E cannot be the basis for criminal liability. In the years that followed, other courts would grapple with more specific statutes in different contexts. But the core of Lawson's victory kept working. The state cannot make a crime out of failing to comply with an officer's undefined expectations. That line still guards the border between lawful policing and arbitrary control. What changes after a decision like this? On paper, statutory language changes. Legislatures revisit the words they use, trimming out the puff of phrases like credible and reliable, and replacing them with clear requirements. In training rooms, officers are taught that requests during lawful stops must be tethered to defined standards, and that an arrest cannot hinge on whether an explanation merely felt insufficient. In communities, people who have been told to move along for a lifetime have one more tool to stand still and say, "Show me the rule." For Lawson, the resolution is less visible but no less real. He kept a promise to himself that place would not be taken from him. He took the time to learn a system designed to make people give up. He lent his name and his body to a case that others have studied for decades as a turning point in the law of police-citizen encounters. Even those who have never heard his name live with his legacy when they walk home at dusk and are not required to carry a story as a pass. For the broader fight against racial profiling, Calendar is both a win and a warning. A win because it clipped a statute that magnified bias. A warning because the urge to recast old control in new language is strong. Vague laws tend to return with fresh labels. They promise flexibility and deliver arbitrariness. Lawson's case gives lawyers and advocates a sharp tool. Point to the absence of standards, to the invitation to discriminate, and demand that the law speak clearly or not at all. It also gives legislators a task: write laws that are as precise as the power they confer. It is tempting to treat stories like Lawson's as relics of the past, but the questions his case raised are very much alive. Which bodies are treated as suspicious by default? How do we measure when an officer's discretion has become a license? What does it take to convert a lived pattern into a legal principle? If the answers are uncomfortable, that is because they are supposed to be. Comfort never needed a constitution. Power did. Lawson's insistence on clarity, on standards that are public and fair, is part of the ongoing work of making policing accountable to the people it serves. The headline says 8 times then number 9. The truth is harder. It took roughly 15 stops for one man to force the law to look at itself. Edward C. Lawson's story is about more than a Supreme Court citation and a line in a casebook. It is about a person who refused to let a vague statute turn public space into a maze of private gates. It is about a court that remembered its job is to demand clarity when the government writes criminal rules. And it is about what the rest of us can do now. Learn your rights and teach them, to your children, to your neighbors, to anyone who has been told their presence requires a permission slip. Support data collection and transparency around stops. so that patterns cannot hide in anecdotes. Press your local and state lawmakers to audit loitering, vagrancy, and stop and identify laws for vague language, and to rewrite them with the precision freedom requires. Demand training that translates constitutional standards into street practice, because due process is only as strong as the next encounter. And remember the quiet courage that moved this story. A man kept walking. He kept saying no to a rule that was not a rule. He kept going until the law changed. That path remains open, and it remains necessary. Edward C. Lawson didn't make the world perfect. He made it clearer. He moved the line so that fewer people would have to live beneath someone else's undefined expectations. In a nation that calls itself free, that is not a small thing. It is the work itself.